All right. So tonight we'll talk about paid leave and how it applies to workers. I am Andrea Barton Reeves. I'm the CEO of Connecticut's Paid Leave Authority. I came to the Paid Leave Authority in March of 2020, right before the pandemic hit. And before that, I ran a large nonprofit that had served people with intellectual disabilities and their families. So let's just talk a little bit today about the Paid Leave Authority. I don't know where my agenda went, but we're going to talk about the Paid Leave Authority and how you apply for paid leave benefits, and just try to answer some general questions that you may have at the end of our presentation. So first, let's talk about the Paid Leave Authority. We have 5 primary responsibilities, and they include the ones that you see there on the screen. We are at the ones at actually both ends. We're engaging in outreach and engagement, where we're trying to educate as many people as possible about the paid leave program and how it works. And then starting this month, we're accepting applications for paid leave benefits, and next month, paid leave benefits will actually be payable. And here is a brief timeline that summarizes all of that. So in the beginning of this year, as I'm sure you all know, we all had that 0.5% deducted from our paychecks to go into a paid leave trust fund to pay benefits that will start in January. Starting this month, actually last Wednesday, you were able to submit an application for benefits, and the next month, those payments, you can continue to submit an application, and then payments will start for qualifying applications in January. So who is covered by the paid leave program? A covered employer is one that has 1 or more employees working in the state, and that does include not-for-profit entities and private sector employees whose workforces may be unionized. If you are a sole proprietor or a self-employed individual, the statute allows you to opt into the program, and if you do so, you do have to remain in for 3 years. You make the same 0.5% contribution as other workers, and even if you're a sole proprietor and you choose not to enroll, if you have people that work for you and you issue them a W-2, then you have to enroll them in the program and withhold the contributions. So who's not covered by the program? Those that work for the federal government and some state of Connecticut employees. Generally, municipalities, towns, cities is a long list of what constitutes a municipality, local or regional boards of education, and non-public, independent, essentially elementary and secondary schools are not part of the paid leave program. There are some other entities that are also not a part of it, and they include railroad workers and people that live in Connecticut but work for other states. We have people that work for the University of California, they work for Iowa State, and they are not covered because they work for governments of other states. And the employees of sovereign nations, so that the 2 sovereign nations that own our casinos in the state, they are not covered by the paid leave law, as are people who work interstate, mostly truck drivers as an example, and spouses of active military members who are still paying taxes in their home state. But if you in fact are a covered public employee, then you are defined as a non-unionized employee of the state of Connecticut. And if you are unionized, you can collectively bargain to be included in the program, and then your bargaining unit will be included. This is different if you work for a municipality or a local or regional board of education, because if the unionized employees in those workforces choose to participate through collective bargaining, then everyone at that workplace, whether they're in the union or not, are then part of the paid leave program. And at the bottom of the slide, you can see the extensive definition of municipality, and it includes towns and cities, how we usually think about them, but it can also include a tourism district or a flood commission. So now what happens to that 0.5% that's been collected? It is collected through employee contributions, withholding through your paychecks, and it is remitted quarterly to the Paid Leave Authority. They are in fact post-tax, and they are based on your FICA wages. There's a cap to the salary against which that 0.5% is charged, and the most that a person is really contributing is $714 a year. So once that money comes in, the amount of money that's being contributed is confirmed by the authority through other resources that we have. They are deposited into the trust fund, and it's the trust that pays the benefits for paid leave starting in January. Now, this is what can get confusing. We know that there's a new paid leave law, but there has always been a Family and Medical Leave Act in the state since the 1990s. So I'm going to talk a little bit about those and then show you a comparison chart. So let's start off talking about family and medical leave, because what we're really talking about tonight is getting wage replacement for the time that you are out for family and medical leave. There's always been a family medical leave law in the state since the 1990s. There's a federal and there's a state component. And both laws allow eligible workers to take what's known as job protected time away from work. So that's the time that having worked a certain number of hours and a certain number of months for an employer, you can then take family and medical leave and enjoy the protection of having your job back when you return from work. That leave has always been unpaid. Some employers have tried to cover that leave by creating their own paid leave programs or asking workers or requiring them to use whatever time they have accrued, which is PTO, vacation, sick, whatever kind of pool they have, to cover the time that they're out so that they don't go without pay for the entire time they're out on FMLA. Now, two things are going to change next year. And so the first is, actually, I'm going to come back to this slide. Let me go to what CTPL is. So the other thing that we need to talk about is what is paid leave, because now what we're talking about is paid leave is what you can apply for when you're taking family and medical leave. So now you don't have to take that leave without any wage replacement. And we refer to it as the law, the program, and the agency altogether. It is only a source of income replacement benefits for the eligible reasons that you take FMLA, but it does not provide the job protection. So if you think about it this way, you go into your employer's office and you say, I am having surgery. It's a serious surgery. I'm taking it 45 days from now. I'm going to have it 45 days from now, and I'll need to be out for 6 weeks. That it will usually be your typical family and medical leave reason for going out on leave. It's considered a serious health condition. Now your employer is saying, oh, it's a long time to be out. How are you going to get paid for all that time? And one of the ways that you can get paid is applying to the Paid Leave Authority, because it does have a source of income replacement for eligible employees who are taking FMLA. We also refer to it as Paid Family and Medical Leave, or PFML. Now, let me go back just a little bit. Let me just talk a little bit about the comparison. So as I mentioned before, family and medical leave has always been around. It's a state and federal law. And it only applied to you if you worked in a workplace that had 50 or 75 people, depending on the state or the federal law. It's always been an unpaid leave. It always offers job protection. The paid leave component is a new law passed in 2019, and it only offers the wage replacement when you are out on FMLA, or this law also covers being out for 12 days for family violence leave. It will apply to workplaces, most workplaces that have one or more employees. And it's really important to understand, it does not offer job protection, only wage replacement. And the maximum you can get is up to 60 times the minimum wage, which right now would be $780. Now, let's see. Here are some important changes to the Connecticut FMLA that you should know about. It does apply to employers with one or more employees, and to be eligible for it, for the job protection, you need to have 3 months that you've worked there, and the hours worked requirement goes away. Your employer can still require you to use your PTO when you're taking the leave, but they have to let you keep 2 weeks of it. So now again, let's talk about this. You got the knock on the door, you come in, I'm having the surgery, it's 45 days from now, I'm gonna be out for 6 weeks. Now your employer is gonna say, if they never said to you before, so let's say you work in a place that has that had 15 employees, so you never had access to FMLA. But starting in January, you'll be able to now go to your employer and say, I want to take family and medical leave because I'm having this surgery. Then your employer is going to say, okay, it applies to me. I have one or more employees. This is a qualifying reason for me to take leave. You've worked there for 6 months. So now you're entitled to get your job back when you come back from that leave. They can ask you to use some of your PTO to cover the time that you're away. They have to let you keep up to 2 weeks of it. And now you can also go to the Paid Leave Authority to get paid for the remaining weeks of time that you'll be out if it's not covered by your PTO. And I will go through all of that again because it is a lot, and we can do that in the Q&A. There are qualifying reasons for taking family and medical leave, and also for receiving a benefit, a paid leave benefit while you're out. They are medical leave, also known as your own serious health condition, and that can also include being an organ or a bone marrow donor, and it does cover pregnancy. Bonding leave is also available, and this is the opportunity to stay with your child as they've joined your family through birth, adoption, or foster care, and create that important emotional and physical attachment that occurs between parents and children. And it's available for all parents, all families, right? Mothers, fathers, same-sex families, it doesn't really matter. As long as you're a parent, you're eligible for the bonding leave, and you can take it up to 12 months after the birth or placement of the child. And again, it applies to adoption, birth, or foster care. If you are a caregiver, you may also apply for FMLA and paid leave if you're giving physical or psychological care or comfort to a family member. If you're taking them to chemotherapy or dialysis, or if they're recovering from a traumatic incident and they need to go and get psychological care, and you're the only person that drives them back and forth to their therapist, that might be caregiver leave, for which you can apply for FMLA, and you can apply for a paid leave benefit so that you don't lose wages while you're taking care of that person. Other types of leave, as I mentioned, is family violence leave. Connecticut is only one of 2 states that offers paid leave benefit for family violence leave. That's up to 12 days in a calendar year. Our state already has a Family Violence Leave Act that allows for 12 days in order to address the issues that arise from family violence. Qualifying exigency leave is the ability for a worker to take time off if their spouse, child, or parent is being deployed overseas. And up to 26 weeks of leave is available for qualifying exigency leave, but only 12 of those weeks are paid. Similarly, family caregiver leave allows a worker to take time off to care for a family member who has been injured during active duty. That leave applies to the worker, not to the person who was in active duty. 26 weeks of caregiver leave is also available. 12 of those weeks is the limit to which there is available paid leave benefit. So all of the reasons that I just listed, those are all family and medical leave reasons. And then you can apply to the paid leave authority and say, I'm taking this leave and I need to seek some kind of wage replacement, so I'm coming to you for that. Let's talk a little bit more about the caregiver leave. Right now, if you were to take FMLA, you can only take it to care for a parent, a spouse, or a son or daughter who's under the age of 18. And if they're over the age of 18, they have to be a person with a disability. Starting in January, there will be an expansive definition of family, and it will include all of the categories that you see on the screen. So if your mom or dad needs to now have, let's say, heart surgery, and you are one of the caregivers in the circle of people who are caring for them, that is someone that you can care for. But now if your grandparent also is having a serious health condition, say they're having a surgery, if you were to take FMLA today, you couldn't take it for your grandparent, but starting in January, if you're eligible, you can. And that also, you can take leave starting next month for people to whom you are related, not by blood, but who you consider to be your grandparent or your grandchild or your sibling. And that is known as related by affinity. And that is, in fact, a relationship with any person with whom the employee believes that they have a significant personal bond that is like family. And those are the people that are listed in the statute, right? So the parent, spouse, child, sibling, grandparents. And we have some examples here on the screen. Very often, we may have grown up with someone who is let's say our godparents, and they've been at every major event in our lives. Now you're older, they're older, they need your help and support, and you consider them to be your grandparent or a parent, and you want to be able to take care of them. You can apply for leave, family and medical leave, to take care of them, and then you can also seek a paid leave benefit to do the same. So now, how does one become eligible for all these leaves that I keep talking about? Again, I mentioned that there has always been a federal FMLA, and that is still in existence, and it still remains the same. That does require you to work for your employer for 12 months. It only applies to employers with 50 or more employees. But you have to work a number of hours, and you have to work for a number of months. Starting next month, in order for you to enjoy Connecticut family and medical leave, you now only need to work for your employer for 3 months, and there are no hours worked requirement. This was not always the case. Again, I always say, if you take it today, you would have had to work 1,000 hours and 12 months for the employer. But starting next month, that will no longer be the case. and you have your job protection, getting your job back after you get back from your FMLA. To get your wage replacement from the Connecticut Paid Leave Authority, you have to earn at least 23.25 in the highest earning quarter of the past 4 or 5 quarters, right before the time that you applied for your paid leave benefit. You need to be working, or you're in a 12-week window right after you've stopped working, and if you're unemployed. So if you were working through let's say the end of January of any year, and so through February, March, and April, assuming each month has 4 weeks, you could apply for a paid leave benefit through April, even though you're no longer employed, because that's the 12-week window after employment. If you're a sole proprietor or self-employed individual, there's a residency requirement, but you can still apply for your paid leave benefit. You do have to live in the state. How much time do you get off? Again, under federal, it's 12 weeks in a 12-month period. And I mentioned the 26 weeks for military caregiver leave and qualifying exigency leave. What I want to point out here is that if you are experiencing incapacitation during pregnancy, there may be an additional 2 weeks available for leave if that incapacitation if those 2 weeks are deemed necessary by your caregiver. The same reasons you apply for FMLA, as I mentioned before, you come over to the Paid Leave Authority and you apply for income replacement. How do I do that is the question. The first thing you need to do is to create an account with the Connecticut Paid Leave. And we really do encourage people to apply online because it allows you to create accounts that can secure your information online and allows you to come back and sign in and be able to see the status of your claim. You don't have to sign in or sign up online in order to apply for a paid leave benefit. I am going to, in the end, give you a phone number that you can call, but it's also on our website, a number you can call to AFLAC to apply if you want to. But you start out by signing in, and there's a video that teaches you how to do it step by step. Once you sign in, you create an account, then you can follow everything from beginning to end. You can view your status of your claim. You can check payments. You can add time to your claim if you're going to be out longer than you think you will. You can send messages to your case manager. There's all kinds of things you can do within the portal. So you can see here, pretty simple. You go to ct.gov, you create an account using your username and a password. You click on that sign up now. And then you create an account. You do have to use an email address that you're going to have access to because you'll need to get a verification code. And every time you sign in, we do verify because, again, you're putting in really personal information about your health condition and why you're taking leave. So we need to have that secure. And that's why we ask you to sign up for a ct.gov account. And please note that once you create this account, please choose your username carefully because we won't be able to change it for you. So please choose it carefully, secure it, write it down for future reference because we don't have the ability to change that for you because it is literally a statewide ct.gov account. So once you do that, you fill everything in, you click submit, you have to choose to indicate that you're not a robot, you hit submit. Then it will email a verification code to your email and you put that code in and then you hit verify and you will then be able to log in and there your name will appear and then you're all ready to fill in your application and start your application process. Again, you'll be getting copies of these slides so you can reference them again. There are different types of leave that you can take. There's something called a block leave, which is how we think about it, just big blocks of time, weeks at a time, usually taken when you're having surgery or your doctor says you have to be out for some extensive period of time for recovery. There's also something known as a reduced schedule. So if you normally work 40 hours a week, but for the next 8 weeks, you'll need to work 20 hours because you will have recurring treatment or you're caring for a sick relative and you need to be off a day or two a week. That's known as a reduced schedule and leaves can certainly be taken for that. Finally, the third type of leave is what's known as intermittent. It's usually taken in separate non-consecutive blocks of time rather than the block or the reduced schedule. And it can be for things that are unexpected illnesses like migraines. You don't always know what might trigger one. If you have colitis and other kinds of health conditions people have, or you may be receiving treatment and it might not be on a regular schedule, or you don't need to take reduced schedules. You don't need to have a reduced schedule in order to address your health condition or a family member's. So these are the 3 types of leave that are available. Now, as I said, you can create that ct.gov account, but now you're thinking to yourself, all right, I've got an FMLA qualifying reason for leave. I have to be out for 8 weeks. I only have 3 weeks of PTO. I'm going to use one of those weeks to cover the time I'm out. I need to get some wage replacement. I'm going to now apply to the Paid Leave Authority, but let's say I'm going to call. So you call or you sign up online, and it is the worker that does that, and you'll be asked to give all of your required documentation. And you can do that with a checklist that you'll be provided in a welcome packet, no matter how you file your application. Your employer will be asked to sign an employment verification form, which they then have to return directly to AFLAC. AFLAC, under our supervision at the Paid Leave Authority, determines worker eligibility. So you may not be eligible if you don't have a qualifying reason, if you haven't earned enough money, those kinds of things. And they'll let you know if some documents are missing as well. Let's go down what we call the happy path, and you have everything and you qualify, and then you'll get your benefit. So the way that will work is there's a 2-part formula in the statute. If you're earning at minimum wage, you'll get 95% of your weekly earnings. If you earn more than that, the formula is a bit more complex, but no one gets more than 60 times the prevailing minimum wage. And right now that is $13 an hour to give you $780 in max benefit weekly. The benefit payments are issued in 2 forms, either direct deposit to a bank account or through what we call a stored value or a Visa debit card. There will be no checks. And payments are made 2 weeks in arrears on a Tuesday. And there's an example there. If you are approved and your benefits and you're eligible for benefits starting the first week in January, your first benefit payment will be on January. Again, a little bit more detail about how much you'll get. If you earn minimum wage, you'll get 95%. And then if you earn more than that, you get 95% of 40 times the minimum wage, plus 60% of what you earn, and that number, and that eventually gets you the number that you get every week. But again, no one gets any more than $780 a week. How do I know this, and how can I figure it out on my own? We do have a benefits estimator on the website. If you go to the employee section, you'll find it there. And we gave you a couple of scenarios here. So here's a worker that's earning minimum wage. They get $520 a week that they popped into this estimator. And you can see on the bottom left, it tells them that they will most likely get $494 a week. There are lots of factors that go into determining exactly how much a person gets. So I really want to emphasize that this is just an estimate. There's all kinds of things. Do you work for 2 or more employers? Is one employer covered under the plan and the other one not? Did you earn the $23.25 at one employer or multiple employers? So there's a lot there. This is just to help you get a sense of how much it might be. And then here's the example for a worker that earns above minimum wage. They are $600 a week, and they will get about $542 a week once we do the math with the formula in the statute. So what happens if you work for an employer and they offer some kind of benefit that you can match or coordinate with your benefit? Again, the employer can require or permit a worker to use their sick, vacation, or other time, but they have to let them keep 2 weeks of it. Whether or not their short-term disability policy can be used with a paid leave benefit is all determined by the terms and conditions of the short-term disability policy. So to start with, let's say that the worker does not have any employer-provided PTO. Either the employer doesn't offer it, or they haven't worked there long enough to earn any. They come directly to the Paid Leave Authority to get paid for the time that they're out on FMLA. If they do have PTO and it pays them for the full amount of time that they will be out on their leave, and their employer requires them to use their PTO or permits them to do so, then they would not be eligible for any benefits because they're getting full wage replacement. If they get, in scenario 3, for example, some of their time, so let's say that the the employer says, you know what, I'll pay you for 4 hours of the day for your PTO, and you can go to the Paid Leave Authority and pay for the rest of the remaining 4 hours of your day, which some employers do. In that case, you do get, we will reduce the benefit amount so that you won't get more than 100%, but that combination of payments is certainly permissible. And then finally, this is more for a block leave. Let's say that the worker does get some employer provided time off that is their regular pay for a portion of the time. All right, so as an example, the worker is going to be out for 8 weeks. They have 3 weeks of PTO. They get to keep 2 of them. So they'll be paid for 1 week through their PTO, and now they've got the other 7. Let's go with an 8 week. So now they've got another 7 weeks that they have to cover somehow. They will get that 1 week from their employer, and the rest of the time they can come to the Paid Leave Authority. But we won't start to pay until week 2, as an example, because you've received full benefits for week 1. Some of the things that you should be thinking about when you're talking about getting your benefit from the paid leave, you should find out whether your employer is going to require you or will permit you to use any of your time off, because that will affect the amount of your benefit. You also need to know if there's any rules about how you should be using your PTO, your sick, or your vacation when you're out on FMLA, because some employers do have rules around that. And if your employer, in fact, does offer a short-term disability policy, it's really important to know how that policy works. And we will be asking the employer as well, how does it work, so that we can adjust benefits accordingly. As a worker, your responsibility is to go ahead and report and file your own claim with CT Paid Leave. Employers will not be doing that on your behalf. And once you do, if you do it online, as I mentioned, you will need to create that account with ct.gov. You'll be assigned a case manager, and that case manager will give you a list of all of the documents that you need, and you'll return those in the time frame that you get. Usually it's about 30 days. You can get up to 45 if you need it. And then if there are any changes in your situation, you need a longer leave, or it's gone from block to intermittent, whatever the changes might be, you're going to want to report those to your case manager as soon as you can. So let's go back a little bit to the family and medical leave part that I was talking about earlier. As a worker, it's important for you to notify your employer as soon as you can that you're going to need leave. You need 30 days in advance if you know it, and as soon as possible if it isn't foreseeable. Once you do that, then your employer has to let you know within 5 days whether or not your leave is eligible for job protection, meaning it's covered under FMLA. This is not the same thing as approving it. It's essentially a first step to say, we think the leave you've asked for is covered under FMLA, but I'm going to need some more information as an employer. They're going to give you 15 days for you to get them that information. And it could be a medical certification from a doctor or adoption records or whatever it might be. If you're having trouble getting those documents, you can get 15 additional days. Some employers may give you an additional 15 on top of that for a total of 45. But usually if you can't get it in within 30, most employers will just deny that leave and then give you a chance to resubmit the paperwork and essentially start the clock again. Once you've turned in everything to your employer, they have 5 days once they've received everything to tell you whether or not your FMLA has been approved. Now, they also have to tell you how you need to use your PTO, when you have to report and how. And if you might need some kind of fitness for duty, if it's your own serious health condition, to come back to work. Your employer will also track your leaves to make sure that you don't exceed the 12-week limit. And you need to let them know if there's any changes. And when you come back, if you've been working for your employer for 3 months or more, when you go on leave, when you get back, you have job protection and you're entitled to return to the same job that you had, same schedule, pay conditions, all of that when you get back. Just a few reminders that even if you're approved for Connecticut or federal FMLA, you still have to follow the rules for call-in and attendance. And there might be some other laws that might apply. And this would be a discussion that you would have with your employer. And we list a few of them there for your consideration. And this last point is important because sometimes we may have an unexpected leave, for example, or become unexpectedly ill, or someone in our family might be, and then we're out for longer than we thought we might be. And sometimes we don't want to use up our FMLA eligibility. So we may tell our employer, look, I am just going to be here with my grandmother for the next 4 or 5 days. I'm just going to use my vacation time. I don't want it to be paid time off. I don't want it to be FMLA. Employers do not have that option. They don't. They have to designate it as FMLA in order to for the job protection to attach, because should anything happen in the time period that you're out and your job is in jeopardy, then both you and the employer will then have a significant challenge that might end up at the Department of Labor and other places that people don't necessarily want to be because of a disagreement around FMLA and work. I've covered a lot of things this afternoon, so I'm going to point you to 2 places where you can go. On our website, this right here, the process, if you pull down and go to employee, you will find a page there for you, which is where you can find a benefit calculator. You can join our mailing list. There's more information, and you can submit a question through our contact us portal, which you can also find right here. And that should be what I have for you tonight. We do have, if you have questions, we are here to help. We do not have a call center because we only have one source of revenue, and call centers are extremely expensive. So we do our best by using the contact us. If you check off the box that says that you need to call back, someone will call you back. If you submit an email, we're asking everyone, please check your spam, because we respond to questions within 24 hours. So if you didn't get an answer, it's probably caught in your spam. We do have a lot of frequently asked questions and helpful videos on our site if you're interested in any of those. And this is the end of my presentation. I want to thank you and see if you have any questions at all. I can't see any in the Q&A. Does anybody have any questions that you want to ask? Okay. All right. If not, then I hope you found this helpful. And as I said, it's recorded and everyone will have an opportunity. Oh, wait, somebody just submitted one. Let's see. All right, so let's see. If I've only been with my employer for less than a year, I will be eligible for Connecticut family leave, but my job will not be protected under the FMLA. Yes and no. I know this is typical. So this is a typical lawyer answer. So let me answer it. Yes, Tanya, I don't want to mispronounce your name, but yes, the recording will be shared with everyone who has attended. So you'll get those slides, and you'll also get the presentation. So here's the way that it works. I just want to answer the person who submitted this question. There's federal FMLA that still exists, and it applies to employers that have 50 or more employees. If you work for an employer that has 50 or more employees and you want to avail yourself of federal FMLA, then you do have to work a year, and you have to work 1,250 hours for that employer. And that will remain the case until the federal government changes that. Starting in January, if you want to access Connecticut family and medical leave for job protection, meaning you get your job back when you come back from leave, you don't have to work any number of hours. There's no hours worked requirement, and you only need to work for your employer for 3 months. That's it. Those are all the changes that are coming. This Connecticut paid leave law family and medical leave law used to be like federal law. You have to work for your employer for a year, and we had a slightly lower requirement. You have to work 1,000 hours as opposed to 1,250 hours. And that's when the job protection would attach. But now, starting in January, if you start January 1 and you work for your employer through March 30th, you go out on family and medical leave in the middle of April. When you get back in July or whatever the month is, not exceeding the 12 weeks, you will enjoy job protection, and you won't have to be there a year. You won't have to work 1,000 hours in order to do that. So I hope that answers your question. And I think that's the only question that there is. All right. Does anyone? Oh, here comes another one. Oh, okay. You're quite welcome. Okay. If anybody has any other questions, I know it is late in the evening. We try to offer these at different times so that people have an opportunity to see them at different times of the day. But I will let you go. And I just really appreciate you being here and watching this presentation. And again, you'll get a copy of the presentation, and you'll also get the recording. So I want to wish you all a good evening. Thank you.